unSILOed podcast is produced by University FM, elevating the stories of your institution.
Welcome to unSILOed. This is Greg LeBlanc, and I'm here today with Greg Makoff, who is a physicist turned banker, now currently a fellow at Harvard Kennedy School, and also the author of this book, Default, the landmark court battle over Argentina's $100 billion debt restructuring. Welcome, Greg.
Thank you for having me, Greg.
Well, look, this book, I really enjoyed this book for a number of reasons, not only because I am interested in sovereign debt, but also because I'm interested in Argentina. I actually was in Argentina at the time when they defaulted in 2001. But this book, I mean, it's economics, it's law, it's whatever, but it's really like a thriller. I mean, in my view, it's one of those books that you go to. I think, we were talking about Michael Lewis and, Barbarians at the Gate, these books, which, read like fiction almost, but they also provide you with a bit of a tutorial on some super interesting things that are happening in the world. In this case, the world of sovereign debt. Now, I remember I think it was in 2001 when Ann Kruger, who was, I think, at the IMF at the time, she pointed out that there was this huge gaping hole in the financial system, which was the lack of any kind of bankruptcy system for sovereign governments. And, of course, we all know bankruptcy is an incredibly useful thing. And it's not just there for the debtors, it's there for the creditors. And if it didn't exist and the creditors could somehow do so, they would all get together and create this thing in order to prevent, a race to the bottom, picking apart of the debtor. And so I remember when she said that, and of course that was right around the time of this default. And I think, we still haven't solved that problem, but we've made some changes, I think, as a result of this case. So maybe we could start off by just talking about that problem. And you worked in emerging market debt, I think, for many years. Why is it that we don't have an orderly process or system for sorting out government debt? Some kind of Chapter 11, which everybody could agree on, because sometimes governments take on too much debt, just like companies and individuals. But there's no automatic stay, there's no fresh start, there's none of that good stuff. So why is that?
The answer is the word sovereignty. And it's you can ask the similar question is, well, why isn't there an international court that makes wars not happen? And it's a country wants to go to war, you can't stop them. A country doesn't want to pay its debt. In effect, when you buy a security, a bond, a loan from a foreign country, and they don't want to pay, there's not much you can do about it. But Argentina's default of 2001, where you were there on $100 billion worth of bonds, was the test case. Because when we use the word sovereign bond, we mean a country issuing bonds under the law of another country. So most of Argentina's bonds were under New York law or English law. So then creditors say, well, you're a foreign country, but I'm going to sue you in the New York courts. Nevertheless, there's not a lot of power in New York to do anything about it. And that's what the case is tested. But Ann Kruger is a critical character in the whole story from a dramatic and theoretical perspective. She starts off the book as Cassandra, saying, there's this gaping hole in the world. There's no system to restructure debt. And there's the bad hedge funds out there. One named Elliott Associates, who just made these tens of millions off of Peru, disrupting their transaction. We need to change the world or there's going to be a mess. And there was a horrific mess, 15 years of litigation. And so I tell that story, bringing readers through it play by play.
Well, look, I mean, I understand why it's difficult to go after sovereigns, right? They can do as they please in many cases. But, an orderly process for resolving debts could boil down to consensus among the creditors, right? So, I mean, in this case, Argentina was able to divide and conquer, so to speak, right? And it's only because they were able to kind of divide and conquer that they were able to access the capital markets to some degree. So, I mean, couldn't you have a system whereby all of the creditors within a particular jurisdiction, at least, were bound to work with each other in some kind of unified way?
Well, there are two problems that come out generally, but in the Argentina case in particular, two impossible problems of sovereign debt. So the first one we mentioned is you can't make a foreign country do anything it doesn't want to do. The second one is if you give plaintiffs the right to sue, and under the US laws, every one of them has the individual right to sue, you have the holdout creditor problem that if there are 10,000 creditors and the government makes a deal with 9,000 of them, then 1,000 could still sue. Mm-hmm. There's no way without a bankruptcy system to have a binding vote blessed by the judge to stop it. Then the government 10 years later settles with the 10,000 and the last 1,000, and then 900 agree to a deal, but 100 keep suing. And they go another 10 years litigating with the last 100, and then 99 of them settle with the government, and the last one keeps suing for another 10 years, and it goes on for decades. So Argentina had two problems. The deal it's restructuring, you had a small group of hedge funds, not just Elliott, 5 or 10 in a tight group, going to play the game to the very end to make as much money as possible. And then you had Argentina playing hardball to the very end to pay as little as possible. And you had this poor judge, Thomas P. Grisey, in the middle without adequate tools to make it work. And the fighting went on and on and on. And he ended up doing something completely unprecedented to bring it to the end. And then that didn't work. And then finally, common sense prevailed.
Right. But look, I mean, the problem exists because you have such fragmentation among the creditors. I mean, if you just had like one lender, this wouldn't be a problem, or even like a small group of lenders that were kind of, working together. And we kind of had that for a while, right? I mean, there was a time when most of the sovereign lending was done by banks, right? And all the banks were super cozy with one another. And then we kind of switched to these bonds, and in a way that was kind of going back in time, because I remember in the 1800s when all the U.S. states got their financing, they used bonds, and all the South American countries, they sold bonds in the London stock market. Even imaginary countries, right, were selling bonds in London. So first of all, why are we back using bonds? Why not just have banks? Because then they can sort of sit down with the debtor and do some kind of workout. And I guess, I mean, that's sort of what the IMF. If the IMF is the lender, then the IMF can sit down and do a workout, so to speak, right?
Yeah, what you are bringing up is what we generally call a collective action problem. In the 80s, in the 70s, banks were the primary lender to sovereigns. It had been bonds, but then in the 30s defaults, countries stopped issuing bonds, especially after the breakdown of Bretton Woods and the oil crisis. Banks started upping their lending to developing countries a lot. So when you got to the crisis of the 80s, all the loans were with the banks. But then with those restructurings, the bank said, we want to get out of this business. And they swapped all their loans into what was called Brady bonds. And after that, countries went straight to the market. In the 90s, this global bond market growing, and asset managers, pension funds, all sorts of investors around the world started building this big liquid market for sovereign debt. And countries like Mexico became very creditworthy, and Brazil and Philippines and South Africa, Indonesia. And so there's this almost $1 trillion market built with a wide variety of different sovereign credits under New York and English law. But when defaults happened in the 80s, most of the credit was owned by the top 15 banks, let's say 2/3, and maybe another 100 or two small regional banks own the rest. They'd form a committee with 8 to 10 people. They'd work out a deal across the table from the country with the IMF in the room and the World Bank in the room, and they'd settle it, and there would be no litigation. Maybe 0.5% of the debt was owned by a difficult person who brought a little litigation, which increased in the 90s, but it was really tiny. But when they swapped all those loans for bonds, you had tens of thousands of holders when a country defaulted. And Argentina was the first messy one. 152 different bonds in 7 different currencies under 8 different laws, hundreds of thousands of retail holders in Italy, hedge funds, asset managers. It was the biggest, ugliest mess. It was always going to be difficult. And then Argentina and creditors went to war with each other, on top of it being a naturally difficult process. So it's the collective action problem is there was no way to get them all into the room. And the result of the entire saga and the mess and the court rulings and the disruption after the main ruling by Judge Grisey is the market said, we need something to fix this collective action problem. And the market agreed on the suggestion of the US Treasury to put very powerful collective action clauses in bonds so that if a country has 20 different bonds for $30 billion, and if 75% of them agree to a deal, it binds 100% of them. So no longer is this game that if there's 10,000 holders, the last 100 can hold everybody else hostage. If you get to 75% or 7,500 of the 10,000, then everybody's bound. There's no holdout game. And so the market, this mess of Argentina will be remembered 100 years from now because it was the learning experience that said we never want to do it again. And instead of developing a bankruptcy system, which like for war under international law is almost impossible to define, we said, let's put it in contracts. So maybe we can't solve the problem of countries being difficult, but we can solve the problem of aggregating creditors, which is an important part of the puzzle.
Yeah, I mean, look, a collective action clause makes so much sense. I mean, not just for the debtor, but I mean, as a creditor, you don't want to be in a position where the restructuring is too easy, but you also don't want to be in a position where it's too hard. I mean, it's like any kind of voting rule. You know, there's probably some sweet spot. And I don't know whether it's 51, 65, 75, but there's going to be some sweet spot that's neither 50 or 0, right? But why did it take so long? I mean, and why isn't that just in the default law, right? I mean, we do have other situations in law where a majority can bind a minority, right? Whether it's unitization trusts or even like the enclosure movement, right? Or business improvement districts, or bankruptcy, of course, is built on this principle. Even class action lawsuits, right? I mean, I was astonished by just how many different tiny little, any grandma with $10,000 could basically launch her own lawsuit. So why isn't the kind of default law in New York something which basically provides this?
Well, you could say default law or default practice or default law under US federal law or default law under New York state or English law. Or it could be in default in contracts. And the truth is, under English law in corporate and sovereign bonds for 100 years, there were always these voting clauses. So you had this sovereign debt market of almost $1 trillion. And you had 70% of it under New York law without collective action clauses and 30% of it under English law with collective action clauses. And when the market took collective action clauses in New York law, they were just doing something England had done for a long time and New York never bothered to do. There's a particular history here. In 1865, before we had big companies, before we had the railroads, there weren't big corporate bonds. Before we had limited liability companies, we didn't have big bonds. But once they formed the LLC form, there became standard forms for bonds. And one of the famous jurists in the UK who wrote why you want to have limited liability companies, because the equity owners don't want to be liable for the debt. But he said, but when you do a bond, you want to have these voting clauses because you don't want to be subject to the tyranny of the minority. He gave all the reasons back in 1865, and the UK said, yeah, we're going to add that. And I think at the time they didn't have a good bankruptcy resolution process. So they knew back then in bankruptcy, there were always people who gamed and held out and disadvantaged everybody else. The holdout game is as old as, Roman law. And so why the US didn't adopt it is that the Trust Indenture Act forbid US corporate bonds from including voting on changes to money terms in corporate bonds. You couldn't change the principal or the payment. And when sovereigns started issuing bonds in New York law, they copied the structure of the corporate bonds, even though they didn't have to, because sovereign issuers are not subject to the Trust Indenture Act. So they used the template corporate bond legal structure, not English law legal structure. And it took 60 years to figure out, we should have started somewhere else.
Right. Yeah. I mean, it made me think of the South Sea Company, right? I mean, the South Sea Company was created as a way of, I think they had close to 100 different types of debt obligations. The Crown did in the 18th century and the 17th century. They just smashed it all together into this, single instrument. So, of course, we all know how it ended up, but that was sort of, a sensible way to do things, kind of. But there's another thing that I found fascinating. I've always found this fascinating, is this whole idea of Champerty, right? Which is an old English law principle, which pops up from time to time. And it basically says that, you're not supposed to be able to buy a litigation claim. But I mean, isn't that what you do every time you buy a distressed security? I mean, you're buying a litigation claim. I mean, why does this thing even still exist? Why is this still this idea of? I mean, ultimately there was some litigation on this, right? What was that? The which case? The Allied Bank case? Is that the one? I mean,
no, it's. Let's back up.
The Peru case.
Yeah, the Peru case, and this concept Champerty. Nobody I've ever heard talk about it for 20 years. This year, it's all over the news. And the story is that during this 15-year history of Argentina's default to the settlement in 2016, where Elliott gets paid out $2.4 billion, huge return. And other people, the total payouts were $10 billion, but they got the biggest piece of it. Other funds getting $1 billion or $500 million. The only thing that slowed Elliott down in this 25 years of investing sovereign debt is in the Peru case. Peru's counsel, Mark Simrot, threw up a defense called a Champerty defense. Elliott had bought 2 pieces of Peru loans that had been guaranteed by Peru, and it was all under New York law. And New York law has on the books from the 1890s or 80s a law saying you can't purchase claims with the intent and purpose to sue. And it looked like that's what Elliott had done.
I mean, what are you going to do? I mean, that's the whole point, right?
Well, the context was you had a Brady program, you had 200 creditors, I don't know the exact number, with $4 billion in claims plus a lot of past due interest, and 99.5% of them agree to the deal. And Elliott says, no, I want to sue. And they'd done the same thing for Panama the year before. And 2 of the people involved with Elliott had been involved with another firm who'd sued 5 countries 2 years before, and Peru's counsel went to Judge Robert Workman Sweet and said, I want to put a Champerty defense where you dismiss this claim altogether, they get nothing. And the judge said, okay, I'll let you pursue it, but I don't think this is very high probability. The reality is other lawyers had gone to other judges in these other cases and said, I want to do a Champerty defense, and the judges just threw it out. They said, these guys bought their bonds to get paid. I'm not even going to let you look at this. Judge Denny Chin in the Panama case against Elliott said, I can't believe Elliott bought $8 million of loans for the pleasures of litigation. Dismissed. You can't do Champerty. But Judge Sweet, he didn't like these guys. And he said, well, I'll let you do discovery. And he spent a year deposing and getting affidavits from the whole Elliott team. So there's this gigantic record of who they are and where they come from. So I put a whole chapter on it because nobody from the investors would talk to me in this book. But I have this 800-page transcript and all the deposition pieces that were put in the court records where they under oath describe who they are and why they're doing it. So it's a very fun chapter. Technically, Peru wins in the district court on Champerty, Judge Sweet saying, you bought this intending to sue. I cancel your claim. You can't have a judgment. They go to the Second Circuit, who says, wait a minute. And they say exactly what Judge Denny Chin said in the other case. By definition, they bought the claims to get repaid. They didn't buy it with the intent and purpose to sue. That was secondary. And so they reversed, and Elliott got their judgment, and they got paid. And so it's like Elliott is the anti-hero of this book. I think most readers don't really want the fund out for big profits to win against the poor country. There's not a lot of sympathy for Argentina by the end of the story, but they're really the anti-hero here. And the anti-hero almost gets completely blown up by Judge Sweet taking away, because if Champerty works on Peru, their business is dead. Then every other judge against every other country is going to throw Champerty. And they overcome this adversity. It took 2 years. And so the Second Circuit kills it. And then there was lobbying, and it's not exactly clear, all the people involved, to go to New York State Assembly and Senate and pass a law that says Champerty does not apply ever to any claim over $500,000. And so so that's the lead up to why people are talking about it now. Is some social activist inspired in New York State, inspired by all the Puerto Rico debt trauma, said, let's change the law in New York State to make sovereign debt restructuring easier. And it was a complicated mess with lots of ideas, but they settled on saying, well, why don't we take out that cap that the hedge funds asked for in 2004 and bring Champerty back to New York State, but only for sovereign debt litigation. And so it passed the Senate in June on the 3rd, I think, and the Assembly didn't vote on it. So there's actually a live discussion, and everybody's saying, what's Champerty? And I said, read chapter 4 of my book about Elliott versus Peru. There's a good discussion of where it is and how it works in real life. But this is a very arcane topic, and you're the first one to ask about it. And it's gotten more live in May because it didn't really become the primary strategy accepted by the New York legislature until May.
Yeah, no, I remember being puzzled by this whole thing, back in law school. It was, a bit bizarre. But what this highlights is how important it is that the judges, like you as a litigator or as a lawyer, if you just read opinions, right, you get the sense that judges are making their decisions entirely based on the quality of the brief and the quality of the argument and the law, and yet when you look at the actual litigation, it's clear that there's a lot of stuff going on between these individuals, right? And the judges get frustrated with certain parties, and they get frustrated with certain lawyers, right? I mean, does this surprise you? I mean, it's definitely kind of surprises me, and sometimes even I don't know, worries me and concerns me that personal relationships matter so much in the law.
Well, I have learned just a tremendous respect for our judicial system. And we have one trial judge, we have 3 appeals court judges, and we have 9 on the Supreme Court. It's a very rigorous system and a very transparent system. And if a judge gets emotional, you have the 3 appeals court judges. This Judge Grisey made an extraordinary opinion. You had 92% of the debt settled with Argentina at a big discount, and the 8% were going to sue forever. And Judge Grisey remarkably blocked payments to the 92 to force Argentina to pay the 8% in full, which is the most extraordinarily unfair thing to do. That 8% get not just 100, but past due interest, so sometimes 3 or 10 times par, while the other guys took 50 cents on the dollar. Totally unfair, but he was mad and there was no way to solve the problem. But it went to 3 appeals court judges who unanimously approved what he did, and the Supreme Court turned down looking at it. And so it was a very fair and transparent process. And I've had finance people who aren't lawyers, who've read the book, and they said, I thought judges were just unemotionally read the law. Right. And the things that you learned is the Judge Grisey got very frustrated with Argentina. He got very frustrated with Argentina's lawyers for the intransigent position of Argentina more than the lawyers themselves. In the final hearings, when Argentina had come to negotiate, they actually had a different law firm represent them in the final hearing. I don't think it made a difference, but they were very aware things had broken down. And the book, if anything, is a study of why did Judge Grisey impose this horrible injunction, and you have the whole record of 10 years leading up to it, and he gets madder. He starts very pro-Argentina, completely protecting Argentina for 5 years. Every ruling is for Argentina. He's the best possible judge Argentina could have imagined, ranting at the plaintiffs, calling Elliott the most faceless organization he has ever seen. And by the end of it, he's so dripping mad at Argentina that he'll do anything to force them to settle. And so it's a study of it, but it also reminds me of who's the Columbia law professor who writes about class action litigation. At a certain point, class action judges, they just got to get a deal done. It's complicated, it's messy, it can go on forever, but at a certain point, there's a pragmatism.
Yeah, well, the case pipeline that they have to deal with. I mean, at some point, they have to ration their attention, right?
Yeah.
And they just have to keep things moving. And so they get upset with anybody who's like, slowing down the process. But I guess, I mean, if you're Argentina, it's very difficult for you to maintain one position in the courtroom and another position out in public. I mean, this was something which the Peronists had as a central plank in their political life, right? Which was, we will not deal with vultures, right? We're not going to talk to them. We're going to ignore them. We're going to just, stonewall them. And so you can't actually have them in court, chatting or, in settlement talks, chatting, and at the same time tell the world that you are not going to talk to them, right? So, I mean, did Kirchner more or less, commit him and herself, the 2 Kirchners, did they more or less commit themselves to a policy that ultimately tied their hands and made it difficult for them to cut a deal with the holdouts?
It evolved over time, but let me say one thing before it, because there's the domestic political audience and then there's the court audience. And you had cases later in the story where Argentina said bellicose stuff on domestic TV. And the hedge funds lawyers went to the Second Circuit and said, look, this is what the president said on TV. And the Second Circuit lawyer just said, politicians say things. We know that. So they're like, they get it. They only care what they do and what the court did. It's not that the court, that Argentina said all sorts of stuff domestically. Even the Second Circuit, before making the final ruling, sent a letter to Argentina, said, you know, the remedy for this blockade is we pay the hedge funds in full, upfront, in cash, with all past due interest. Would you agree to an alternative payment plan, which could have been less money paid over time? And Argentina said, no, they take my other deal or nothing. And so then the Second Circuit wrote this scorching opinion saying these guys are a uniquely recalcitrant debtor, the most uncooperative people we've ever dealt with. So they did cite the bellicose statements, but the real energy here is they gave them a window. And so it's the bellicosity of the political statements is a signal, but it's the actual decisions made again and again in court. And Judge Grisey repeatedly asked Argentina, okay, I really don't want to make this ruling. What are we going to do to solve the problem before I make the ruling? And in the earlier hearings, Argentina's lawyer said, oh, we don't have a plan. We'll get around to it someday. And as you said, with the judges need to clear their decks. They need to get deals solved. That wasn't acceptable after 10 years of litigation for Argentina said, oh, we'll come up with a plan later. He wanted the problem solved. And Theodore Olson, Ted Olson, former Solicitor General, said to Judge Grisey, they brought this great appellate Supreme Court litigator into the district court and said, you put on this injunction, they have the money, they're going to pay. They had 50 billion of reserves. There were a couple billion of the holdout bonds owned by Elliott. They'll pay. It'll all be over with, Judge. It'll all be fine. And it wasn't. Argentina didn't pay, and there was 5 more years of litigation. And so it was made as a pragmatic decision and an angry decision. And that's the fun of the book, because you get to see all the pieces of why you made the decision and why it backfired. And then, as I said before, the extraordinary response of the market to say, we don't like this mess. We don't want more blockades. Give us collective action clauses.
Yeah. I mean, look, what I find interesting is that a lot of this boiled down to whether or not there was good faith negotiation. I mean, this even happened early, right? Early on, when the Argentines said, take it or leave it, 70% discount, right? And a lot of the plaintiffs are like, well, hold on, that's you're not talking to us, you're not negotiating with us, and well, I mean, what is negotiation? I mean, if they come in 70%, the other one say no, 50%, no, 70%, no, 50%. I mean, that's not talking. When these courts say, hey, you need to be in good faith negotiation, what does that mean, really? I mean, it means something more than just shouting at each other and sticking your feet in the ground. But what does it mean to actually be talking to each other as sort of a legal concept?
There's a lot. The book is really about 2 things. One is good faith negotiation, getting people to settle their differences and not letting the partisans far on the left or far on the right to dominate the solution. And the other one is the role of arbitrators.
Mm-hmm. And this guy Pollock, he's amazing, right?
Yeah. So in the beginning so there are 2 good faith negotiation fights. The first one, when Argentina wants to pay 25 cents on the dollar to its creditors in 2003, the regular market goes crazy and a bunch of activists attack them and say, no, you should pay 65 cents on the dollar and all past due interest. They want 3 times what Argentina is willing to pay. And Argentina's run its numbers. They said, if we pay that, we're going to be back in default in 5 years. Our plan of the 80s 70s blew up, our plan of the 80s blew up, our plan of the 90s blew up. We do not want to be in default again. We need to make a serious cut here, and then we'll pay. We'll run a big surplus, 3%, and that's it. We can't be in this debtor's prison forever. But what happened is the creditor activists all like, oh, Argentina didn't have good faith. Argentina wouldn't talk to me. Nobody talks about how the creditors were asking for 3 times what Argentina was willing to pay. They were writing letters to the board members of the IMF saying, cut off funding to Argentina until Argentina comes to their knees and pays us well more. So there was nastiness on both sides, and I go into all that detail. And the problem, however, is there was a very unusual policy decision coming out of the 90s where the US was accused of being over-involved in the Asia crisis and stuff, where the US said, for the US and the IMF, don't dictate the outcome of this deal. Let Argentina fight with the creditors. So they were fighting. Argentina was too low, the creditors were too high, and you needed the IMF to come in with their models in the middle and
you needed a grown-up in the room.
Yeah, but for
Stop
some
fighting,
reason,
kids.
For good reasons, the Treasury said, no, let them work it out. But then the creditors started egging the IMF to cut off funding, and it became very embittered and confused. It's hard to figure out whose fault it was, and it all collapsed. Everything collapsed. Argentina overplayed it, creditor overplayed it, the IMF underplayed it, the Treasury underplayed it. The answer is we needed collective action clauses. So it's not like pointing fingers. But then in court, in front of Judge Grisey, it became another good faith discussion. And just to back up, what I didn't explain is when the creditors lobbied the IMF, they said Argentina's not negotiating in good faith because they refused to sit down with a bank advisory committee. In the 80s, when there was a small group of banks, the top lenders sat in a room and worked out the deal with the country. And the creditors said, well, we have 6 people and we want them to negotiate the deal with you. And Argentina had set up 8 different creditor groups around the world. And they said, no, we want to work with our 8 different groups. And Argentina didn't want to go in with these hardcore people who were going to force them to pay way more. And those people had asked for 3 times as much. And they're like, if I agree to only negotiate with this group, I'll be forced to pay more than I want to. No, thank you. I'm not going in the room. So if we had the Trump era, Trump would say, I'm not going in the room with those people until they lower their demands. But when you go back to 2003, the creditors created a lot of noise. And then the IMF called foul on Argentina. But Argentina under Kirchner, they weren't delivering other parts of their program. The economy was doing well, but they weren't fixing their utilities. They weren't doing other things. So it became an unholy mess. Argentina lapsed their program with the IMF and sold their deal on unimaginable threats. If you don't come and do our deal, we're not going to pay you a penny ever. They put it in contract. They put it in law. And it was horrible. And that stunk up court. Because later in court, they're pointing to this law and features of the deal saying, look, Argentina shoved this down the throat of the 92% of creditors who eventually took it. They were threatening. It wasn't properly negotiated. And now they're refusing to pay us. Judge, we have to get back at this evil debtor.
Well, that's the Rufo clause and the lock law that you referred to, right? Where they really tried to tie their own hands to, pre-commit to not negotiating with the holdouts. But the other interesting thing is how the Elliott folks and their other hedge fund co-plaintiffs, they scoured the world for assets, right? I think, I remember when they seized this ship in Ghana, right? I mean, they were just looking for anything related to Argentina that could potentially be seized. And of course, we have this sovereign immunity. So you're not supposed to be able to just go and seize government assets at random. But these guys were indefatigable, and they were looking for money that might become attachable. So could you just say a few things about that, right? So, there's money that is sitting in U.S. banks, but it is for the purpose of governmental business, military business, central bank business, and then there's government money, which is there for commercial purposes, and it's the latter that you can kind of go after, right?
Well, since I'm a banker, let me explain it as an investment thesis. You've got the largest handful of creditors control 65% of the eventual 10 billion in claims. So they have over 5 billion in claims. For them, it's worth it to hire lawyers and scour the world. And for them, it's worth it to send this gigantic team of lobbyists to make a huge amount of noise in Washington and New York State about Argentina. So they spend somewhere between $50 and $100 million in lawyers creating as much noise as possible, trying to attach Argentina assets. And they hired these lobbyists down in Washington, D.C. and all over the world to make a lot of noise. And there was a Wall Street Journal article on June 4th about some potentially particularly aggressive lobbying by some of the people. And it's most of the claim size was less than $1 million. And here you have these kind of billionaire people spending $100 million on enforcement, on lobbying. So you're playing a game among a very elite group of people to even try it. One attachment effort can involve $3 million of legal expenses or $10 million. So they went after, Argentina has this tall ship called Fragata Libertad. And you can see shots of it on my book website, which is defaultthebook.com. There's a little video, a book trailer, and there's pictures of this beautiful ship, 3-masted ship, 350 sailors on it. It's called the Liberty. So it's like a floating Statue of Liberty. The Navy goes on state visits all over the world. It has guest sailors from Bolivia and bunch of other different countries come and sail on it with them. And it was going to make 11 stops in Africa, goodwill visits, and the ambassadors come and the military come. And it had been scheduled for a long time. It showed up in Ghana, and the next day it gets an arrest warrant. And eventually it gets kicked to the International Tribunal for the Law of the Sea in Hamburg, Germany, who says, well, you have to refuel it and send it home. Under international law, you can't attach a Navy ship. So it's what I call a catch and release process. You really can't attach sovereign assets. And again, plaintiffs try to attach Argentina's assets. What happens is they get a temporary attachment order, then there's litigation, and then the country proves sovereign immunity, and then it's released. But it generates gigantic headlines. And Elliott appears as if in the international press, it's chasing Argentina to the end of the world, but it backfires because in Argentina, it's making Argentina look like the victim of these evil hedge funds, which is making President Cristina Fernandez de Kirchner more popular. And so a key point in the book and in the story in 2013, January, the ship is released. It comes back. Cristina Fernandez de Kirchner has the ship behind her in a beautiful sunset, the whole cabinet, the captain of the ship, 10,000 flag-waving Argentines, and a half an hour long speech about the history of debt and the evil hedge funds, and they attacked Peru, and now they're attacking us, and we're going to change the world, and we're never going to pay them a penny. Now, did that attachment of the ship help compel Argentina to settle voluntarily in court, or did that make it even harder?
I don't know, but I have to admit that when they did that, I was impressed, right? When they managed to get that boat. I mean, that was pretty impressive legal work right there. But they did also try to go after central bank money, right? I mean, you have a whole chapter where they managed to actually get their hands on some central bank money, and there was this little thing in there about the what's the term? Oh gosh, now I'm forgetting the legal term. Editors, delete this, right? What's what is it when you're acting as a agent of the state? What's the term?
Alter ego.
Yeah, right. So okay, let me ask that question better. Okay. And so, you have a whole chapter in there about going after the central bank assets. And then there's this whole alter ego idea, which makes an appearance. So, I mean, were there some legal precedents that were at stake right there during that incident?
The fifth chapter of the book, once you get done with the debt restructuring and all the fights, you go into the litigation part. So it's 1/3 of the book is the deal, the messiest deal in history. Then 2/3 of the book is the messiest litigation in history. Sandwiched between is this backstory chapter on Champerty and Elliott versus Peru. The Argentina announced it was going to repay the whole $9.8 billion it owed the IMF in December 2005. It fired the minister who'd negotiated the deal, and President Nestor Kirchner says, "I'm in charge now, and I'm going to pay out the IMF." And it was a big pro-sovereign, pro-Argentina, and Brazil had just repaid the IMF. So it's like, we're South America. We don't need the Washington consensus. And the hedge funds, two of them, Kenneth Dart and Elliott, said, hey, they're using their central bank money to repay another creditor. Let's try to attach it. And so they went to New York and tried to attach any Argentine money at the New York Fed, which is usually pretty hard. But this gave them an excuse of another creditor being paid to not allow sort of a fraudulent conveyance, as they argued it was, money leaking out of the system. And they got a temporary attachment and got another hearing in front of another judge at first, and then Judge Grisey, and then the Second Circuit. And Judge Grisey is like, this doesn't work. And it works well because this all happened in 2006. And in the court, they argue about sovereign immunity. And so I use it to teach the nuts and bolts, but it's not boring like a lecture. It's like you get to hear them argue in court. And basically, the test is you have to find an asset being used for commercial activity in the United States for it to be attachable. So if a country is buying a tanker full of gas and it comes into the port, and anybody in the market can buy or sell a tanker full of gas, you can take it. Mm-hmm. But if the country is paying its embassy employees, that only a country can do it. And so there's regular immunity, which applies to governmental purposes, which is 1610 of the Foreign Sovereign Immunities Act. But there's this thing called 1611, which gives super double immunity to central bank assets and military assets. So if you send in a military ship, you just can't touch it. And central bank assets are very hard to attach, but assets of the monetary authority being used for central banking purposes. And so they attack that, saying, well, that wasn't being used for a central banking purpose. It was being used to pay the IMF. But Judge Grisey looked at that and said, no, this is central banking assets. They only had $100 million in New York. They'd moved most of their $30 billion to the Bank of International Settlements in Switzerland, which has triple immunity. And it went on, a big messy litigation. And the Second Circuit said, this is immune. We're not going to blow central bank immunity to try to force Argentina to pay. But Judge Cabranes didn't really like Argentina. He's a skeptic. I think he's Puerto Rican. He's a Spanish speaker. He follows Latin American politics. And he brought up this theory in the argument with Argentina's central bank's lawyer, saying, well, what about an alter ego theory? An alter ego theory brings up the question of the entity. So if you have a country, the country issued the debt. The Republic of Argentina issued the debt. But if you have Aerolíneas Argentina issued debt, can a creditor of Argentina attach the assets of Aerolíneas Argentina to get repaid because Argentina is the 100% owner of it? And the answer is no, because of a precedent called BANSEC, is a Cuban-related case. Different entities are assumed to be separate, and you can't use anything owned by a country to pay off the government's debt. And so the question was, well, is the central bank a separate legal entity, or is it an alter ego? Meaning Dr. Jekyll and Mr. Hyde are really the same person, and it's really the piggy bank of the government. and you can take all the money out of the central bank because it's really the government. And there was a big beginning of a fight over that, which went on for another 7 years. And so the reason this is important is creditors often have to go to the gas company or the airplane, different entities. And if they can prove it's a central government function, they can take its stuff. But if it's truly separate, but the problem is with the government, it's all their piggy bank. And eventually, if the judge gets mad enough, they'll argue it's an alter ego and you can take their stuff.
Yeah. So it's like basic agency law, right?
Yeah.
So if there's no independent decision making at the level of the entity, if it's just sort of following orders from the minister or whatever, then it's seen as alter ego.
Well, Judge Grisey sat on this for 5 years because after they failed on their initial attachment and after Judge Cabranes opened the door saying, what about alter ego? They went back to Judge Grisey and said, now we're filing an alter ego claim. Right. And Judge Grisey is going, well, you're not allowed to relitigate the same attachment, but I heard what Judge Cabranes says. It seems they're opening the door, so I think I'll allow it. But the plaintiffs are arguing, well, they keep firing their central bank heads, and the central bank keeps doing what the government wants to do. But that's kind of true everywhere in the world. And Argentine central bank wasn't particularly less independent than 60 other central banks around the world, so it was going to be hard to prove it. But in January 2010, the successor president, Cristina Fernandez de Kirchner, she fired the head of the central bank because he wouldn't lend her $6 billion in an election year because he said it would be inflationary. And he left, and the immediate successor lent her the money right away. And Judge Grisey, a month later, gave an alter ego ruling and decided that the money was attachable, which the Second Circuit didn't agree with because they don't want to attack central bank immunity because it's important to all the central banks of the world. They don't like Argentina's uncooperative behavior, but the central bank immunity is quite sanctified. But when it came later to the Parry Pasu and the injunction and blockade, they're like, we don't care about that clause. We'll blow that up, but we're not messing with central bank immunity. So when it came to the later ruling, the court had already turned down turning the screws on Argentina on the central bank. It's a very good barometer. You see Judge Grisey getting really mad in the central bank case. So it's a core part of the story. I don't think another author would have spent as much time on the central bank cases, but to understand Judge Grisey, also to understand all the aspects of sovereign debt law and the importance of alter ego and how that interplays with the regular attachment law, it turned out to be a very rich addition to the book.
Well, and of course, there's ultimately the legal fate of this Parry Pasu provision, and that is sort of has an interesting history because I think that there was precedent that said, hey, this argument is a dead letter, and then it was sort of revived, right? and Judge Grisey endorsed it. So how did that come to be? Because that was really sort of the monumental shift in opinion that led to the ultimate payout, right?
Yeah, we haven't explained it yet. So the thing we already talked about was the remedy. Judge Grisey imposed an injunction to block payments to the 92% of international bondholders that had already settled with Argentina to force the country to pay the 8% in full.
And remember that's something that in normal bankruptcy law that would make perfect sense, right? I mean, that's effectively what standard bankruptcy would impose on a debtor.
Yeah, the reason it worked here, even though Argentina is way down there and we're way up here, is the Bank of New York was the legal agent for payments, and the Bank of New York's located in New York and is subject to the jurisdiction of the court. And if the court makes an injunction against Argentina and sends a copy to the Bank of New York, they are not going to process a payment in violation of a court order because that would be aiding and abetting a crime.
Mm-hmm.
And so that's how Theodore Olson argued the injunction would finally be a way to force Argentina to pay, because you're holding Argentina's ability to finance itself in international markets hostage. You're blocked from the market until you pay, which is a pretty harsh remedy, holding an entire economy hostage to pay off a couple $1 billion of debts. But Judge Grisey and the Second Circuit were infuriated with the lack. So anyway, why do this? So what Elliott found was a clause in Argentina's bonds, which was similar to a clause in Peru's bonds, which it had used earlier, called a Parry Pasu clause, saying you have to treat all creditors equally. And as of the 1990s, from the Brady programs, every bond in the market, hundreds of billions of dollars of bonds, all had this clause. And it turns out, after the fact, Wall Street issued a bunch of bonds and nobody knew what it meant. It was unclear. Some lawyers had written articles, well, it definitely doesn't mean this. But the reality was it was ambiguous. And the Elliott lawyers very cleverly picked up on this ambiguity and said, for me, that means all debt needs to be paid equally. So if Peru,
seems logical,
if
right?
Peru
it seems
is paying 99.5% of its debt, which had been settled at 50 cents on the dollar, but I own 0.5% of the debt, which is still in default, and you owe me par plus all past due interest for 15 years, which is 4 times par. You have to pay me in full my contractual obligation because you're paying them in full their contractual obligation. So their interpretation of Parry Pasu isn't I get the deal others got. Their interpretation is my contract today is paid if their contract today, and we ignore the history of that debt being restructured. So it's a very selective interpretation of Parry Pasu. One could say, oh, I'll give you Parry Pasu backdated to when the restructuring occurred. But their version of Parry Pasu was current contracts all must be equally paid, that the appeals court in Belgium, Elliott lost in Belgium in the trial court, it won on appeal, and Peru didn't appeal further. Peru just paid him and said, I'm tired of 10 years of litigation, 4 years of litigation. They just paid him off. Fujimori was being run out of town. It was a very chaotic moment in Peru's history. And the U.S. lawyers all said, oh, that's a weird ruling. And when Judge Grisey first heard about it, he said, oh, that's a weird ruling. And that's very odd. But when they brought it to Judge Grisey 6 years later, and it was a practical way to solve the problem, in that Elliott's most clever thing in using this, and Michael Strauss, their lawyer who maybe developed this idea for them, was if you get the judge to accept, you have to pay the holdout creditors in full if you make the full next coupon payment on your 92% of creditors. And remember, the 92% have been paid in full since 2005, or some later date when others were settled. And the defaulted 8% haven't gotten a penny since December 2001. You're paying them in full and we're getting paid zero. There is no more unequal treatment than that ever in history. Every time you make a coupon payment, you are breaching the covenant again. You are stabbing me and stabbing me and stabbing me. And to stop this continuing harm, you need to impose the injunction to stop the harm. Whereas what Argentina argued is you suffered a default and the remedy is attachment. And then they said, well, we're trying to attach, but attachment fails. We will never be satisfied. And as a last resort, give us the injunction. Injunction is equity. You jump to equity as a last resort. And so from a legal perspective, you move from law, written law and statute, to equity, and you justify it by saying there's no alternative and there's no way to have a fair outcome without it. And those were the arguments being made in two very lengthy hearings at the Second Circuit. Is this equitable or not? And there you have a dramatic scene where Theodore Olson is arguing against David Boies, who gets hired by the 92%. And he's like, wait a minute, you can't block payments to us. We have valid paying contracts. We have nothing to do with your dispute with Argentina. We have the contracts clause in the Constitution. There is nothing more unfair than putting my payments at risk because you two have a beef. You find another way to solve it, but don't put me at risk. And the Second Circuit let him talk for a long time, but they still imposed the injunction because it was a practical solution. And also David Boies should have been involved 2 years earlier at the trial court with Judge Grisey. So when and how arguments made are really, you learn a lot about it reading this story of how it was litigated.
Well, that's ultimately what brought them to the table. And, I was very impressed with this guy, Pollock, right?
Yeah.
I mean, he seemed to have, these people who wind up doing arbitration, they must have some special capacity for empathy or, be very persuasive. They obviously they have carrots and sticks. And, without a stick, they can't wield their magic, but they do seem to be incredibly persuasive people.
I interviewed Pollock for about 5 hours. He sadly subsequently passed away before I finished the book. And so I couldn't share it with him. I had thought he was hired from a list of mediators, special masters, commonly used by the Second Circuit. And at a memorial for Judge Grisey, I was completely shocked for him to say, oh, we were best friends. And they had Thanksgiving dinner together. And
he didn't know anything about this area of law, right? And he didn't know anything about the case when he took it on.
He worked for mutual funds and had helped sue Goldman Sachs about selling some bum CP, and he'd done some Supreme Court cases. And he generally worked alone. He's a very, very shrewd litigator, very good reader of juries. And he was just friends with Grisey. His father had been a Second Circuit judge, and so he knew how to deal with judges as friends. And the reality is Judge Grisey couldn't handle this case. He was personally exhausted by it. He couldn't bring it to an end. So he kind of leaned on a friend. And it became very clear from when he was brought in 2014, when the injunction was imposed, he brought in Pollock, said, let's settle the thing in the next 4 weeks, then it's all over. And that failed. Argentina redefaulted. It went on for 2 more years. But he brought in Pollock, and he just kind of stopped thinking. He said, Dan, what should I do? Dan says, go to court, tell him to come to my office and stay up all night and negotiate this thing. And so from then on, by the end, Judge Grisey's health is deteriorating. His hearing is deteriorating. People suspect the final removal of the opinion, the final removal of the injunction. When Argentina started negotiating, people suspect that Pollock wrote the opinion for him. So it's a very odd buddy story at the end of this. I don't go into that in the book because that's all kind of inferential, and I stick to the facts of what happened, but it's a very important relationship. And he initially failed to really bridge the gaps in 2014. Argentina went into default. After seizing the ship, Argentina was not going to obey this order. They said, we'll go into default on the 92%, forget you. They were going to have an election in 2015, and Argentina figures, let them all stew in default, and then I'll cut a better deal after. But the Kirchners, the Peronists lose the election. The opposition, Macri, wins, and he sends some smart former bankers to New York to negotiate, and they get to be friends with Pollock, who helps them solve the problem. And there's hundreds of conversations between Pollock and Elliott in Argentina, pushing them together and stopping it. It was going to blow apart at any minute. And he just pushed them until there was an actual bona fide compromise. And you look at this beautiful compromise and you're like, where was Dan Pollock in 2005?
Right.
Why did we go through this mess? Why wasn't there an arbitrator back then?
Yeah. But I mean, a lot of the story, it looks like Argentina's a victim and that these vulture, hedge funds are predators taking advantage of the little guy. But I mean, if I was an Argentine and I was dealing with a political system that was effectively unaccountable and unreliable and constantly in violation of its promises, I mean, wouldn't I want somebody to kind of hold them accountable? Wouldn't I want some external pressure? Wouldn't I want American courts to say, hey, you got to fulfill your promises. If you say you're going to have an independent central bank, you got to have an independent central bank. I mean, aren't the American courts in some ways doing the job that should be done by the institutions in Argentina? I mean, Argentina's defaulted, I don't know what, 10 times. I mean, it's been a basket case for its entire history. I mean, and obviously domestically they're not figuring it out. So what's wrong with having these external plaintiffs require that they live up to their promises?
Well, I think the debt and government policy is eventually decided at home, and foreign judges are not very well positioned to drive government policy. Only at very extreme behaviors can they do anything. The IMF is much more involved with policy, but still only so much an institution like that can do. But what's remarkable at the end of the book, which I finished before this last election, was you have this period from 2001 starts in Argentina in crisis. You have this whole mess happen, and the market says, we need some kind of system. And Kruger was right. We need collective action clauses in bonds. The market immediately adopts it, and today 80% of bonds include these. The problem is largely fixed. All the recent deals have worked very well, and sovereign debt is much better for the learning from this crisis, and Argentina is back in the tank. So it's like Argentina is back at square one. Now, at the conclusion of the book, which I wrote 2 years ago, I'm like, what does Argentina do? It's got a big debt load again. Does it just keep defaulting? Or does it wake up someday and say, we're going to start honoring our debts and we're going to live within our means? And they elected Milei. He came with a chainsaw. He said, we're going to honor contracts. It's going to hurt. But the people are exhausted by crisis of the 80s, crisis of the 90s, crisis of the 2000s, crisis of the 2010s. And they're like, enough. We value financial stability more than we do short-term increased pension, increased wages. And how that plays out is incredibly important. And it's uncharted territory. Some people said in December after the inauguration, Argentina will fail because it always fails. And my response on Twitter is like, this is uncharted territory. We have never had a president say it's our fault. We need to spend less. They've always had other plans. We're going to fix the currency. We're going to bring in a lot of money and grow fast. For the first time, someone's saying, fiscal's the problem. We spend too much. We print too much money. We have inflation. We default. We're going to stop that. And it's important. It's good to see this history of mess and then to see in light of that what's happening with the Milei government. So I'm very happy to say the translation's almost done, and I'll come out with the Spanish version very soon and go down to Buenos Aires to talk about it, which is going to be very fascinating.
Yeah, nice. But I think there's one other point, which is the IMF. I mean, they are supposed to be the ones that supervise the rehabilitation of broken countries, right? Now, I know in these countries, the IMF is a villain, and it's kind of puzzling. It's like making the surgeon and the physical therapist the villain instead of the guy who hit you with the car, and left you on the street with all the broken bones. But I mean, the IMF it's in a way, I think they've failed repeatedly with countries like Argentina. They haven't gotten these countries to do the kind of structural reforms that is usually a requirement for assistance. Why is it that they lack this power? Why is it that they haven't been able to do what they're supposed to do? Yes, of course they get repaid. And if their main job is to get repaid, well, they've succeeded in that. But the conditionality doesn't seem to really have much teeth.
Yeah, I'm more in the IMF camp on all of this. They have the hardest job in the world. It's very hard to model economies to start with. It's very hard to model an economy that's in a disaster. You're going in, you're trying to help them cut budgets. Everybody complains, well, they're making us cut spending. Well, they got into trouble because they were overspending. And their currency problems, inflation problems, it hurts to fix long-standing fiscal problems, tightening the belts. And it's hard, there are mistakes, you have to adjust the program. And but from a political perspective, you often have the elites in a country know they have to shut down an airline or a factory that employs a bunch of people because it's loss making. And they've wanted to shut it for years, but politically they can't. And so the IMF program comes in, and the IMF program has a condition: you have to shut that factory. And they said, the local elites say, well, the IMF made me do it. They wanted to do it all along, but they didn't have the political capital to do it. So the IMF becomes a bad cop in the game. But there's also a degree, so it's really a governance tool that forces the vested interests in a country to break down longstanding problems, which leads to a lot of political noise. But what you have is also certain types of academics and international media people who just accuse the IMF of just hurting countries. And you go to Africa, often the problem, if you look at Zambia, the copper price went down in the mid-2000s. In 2010s, they should have gone to the IMF, but instead borrowed some more bonds and dug themselves deeper in the hole. So what you need to do when your revenues goes down is tighten your belt and get some support, not just load up on funding. And so the biggest problem with most countries, for me, is going to the IMF too slowly, because you're in a deeper hole, you have more debt, it hurts the debtors more, you need a bigger adjustment. So for me, the IMF isn't the problem, it's countries hearing all this negative IMF theory and politics, and that anti-IMF view hurts them. And so I think they do as well as they can. They're a member organization. Are they perfect? Nobody's perfect. You work with them. That's why you need countries to understand IMF programs, how they work. They need to do their own economic models. They need to be proactive with the fund and say, we need this and that. We don't want to do this and that. Countries who haven't planned, you get foreigners come in and tell you what to do. And people from the fund tell me, when we come in early and we have 9 months to study, we have a much higher quality plan than we're brought in 2 months before money runs out and we have to rush a program. It's not analyzed as well. It's not through as well. We make more mistakes. So I think I'm come out of this saying it's a difficult relationship, but they're the last resort. You don't have a choice. Get smarter about dealing with them. Don't villainize them.
Well, Greg, thanks so much for joining me. Look, this book, Default, it's, if you're like me and you like this kind of thriller, I mean, I've never read the Da Vinci Code, but, I'm guessing that's probably, similar degree of suspense. Fantastic book. Check it out. The landmark court battle over Argentina's $100 billion debt restructuring. And it's a story that's, hopefully we won't have another chapter in the book. But I do look forward to seeing more work from you, Greg. Thanks so much.
Well, thank you for having me.
unSILOed podcast is produced by University FM, elevating the stories of your institution.